Honor, Christopher Ballard and Chad Grunander on behalf of the state.
Your Honor, Kathy Nestor, Richard Novak, and Stacy Visser on behalf of Mr. Robinson.
Thank you. Welcome to both the prosecution and defense. Mr. Robinson, I understand, is appearing by WebEx. Mr. Robinson, can you hear us?
Yes, I can.
Thank you. Good afternoon to you all. We're here on the Tyler James Robinson motion to appear in civilian clothing and without physical restraints at all pretrial hearings. Because of some of the arguments involved in court security protocols, the court held a closed hearing on October 24th, 2025. During that hearing, the parties addressed several related matters. The first, Mr. Robinson's motion to strike the sheriff's response. The second, Mr. Robinson's motion to appear in civilian clothing and without physical restraints. The third, the sheriff's and Mr. Robinson's request to limit or exclude visual recording and photography in the courtroom. And finally, the fourth matter, the state's request to have all non-evidentiary hearings held remotely. The parties have stipulated that the state's request to hold non-evidentiary hearings virtually, as well as the parties' joint request to limit electronic media coverage, both require further briefing. Those issues are not yet ready for the court's decision. To facilitate that briefing, the court directs as follows. If the state wishes to have all non-evidentiary hearings conducted via WebEx, it must file a separate motion. The court will not rely on prior briefing. The standard timelines for response and reply apply, and the parties must file a request to submit and request a hearing if desired. If the parties seek to limit or restrict electronic media coverage, they may file a joint motion. Again, the court will not rely on prior briefing. That motion must address the factors set forth in Rule 4-401.01 sub 2 of the Utah Rules of Judicial Administration. Standard response and reply times apply, and the parties must file a request to submit once the matter is ripe for decision. The court took under advisement two issues, the motion to strike and the motion to appear in civilian clothing and without restraints. Court now issues its ruling. In regards to the motion to strike the sheriff's response, the prosecution and the sheriff's department filed a joint opposition to the defendant's motion to appear in civilian clothing and without restraints. Mr. Robinson moved to strike the sheriff's portion of that filing, arguing it was procedurally improper because the sheriff is not a party. At the hearing, all agreed that the sheriff's department is not a party in this case. The state and the sheriff's office nevertheless argued that the sheriff may file memoranda as a non-party. Mr. Robinson disagreed, but did not object to the court considering the sheriff's position on security. The court finds that the sheriff's department is not a party to this case, and therefore its joint filing with the prosecution was procedurally improper. Accordingly, defendant's motion to strike the sheriff's response is granted. However, under Rule 3-414 of the Utah Rules of Judicial Administration, the court is required to coordinate courtroom security with the sheriff's department. Consistent with that rule and with the defendant's agreement, the court has considered the substance of the state's opposition and the memorandum prepared by the court security director that was attached to it. Going forward, if either party has a security concern specific to this case, they may present evidence from the sheriff's department by affidavit, declaration, exhibit, or testimony. This order does not limit the sheriff's department's ability to coordinate with the court or otherwise act as authorized by law. Turning to the motion to appear in civilian clothing and without physical restraints. The parties agree that during trial, a defendant has a right to appear in civilian clothing and that any restraints must be concealed from the jury. Mr. Robinson now seeks to extend those rights to all pretrial proceedings. The court considered each request separately. In relation to request to appear in civilian clothing, Mr. Robinson asks to appear in civilian clothing at all pretrial hearings. He argues that the extensive media coverage of this case creates a real risk of prejudice if the public and potential jurors repeatedly see him in jail attire. The state, the sheriff's department, and the court security director opposed the request, arguing that jail clothing assists with safety and identification. The court has balanced these competing concerns. The case has attracted extraordinary public and media attention. Images of Mr. Robinson in jail clothing are likely to circulate widely and influence prospective jurors. Given the scale of that publicity, the risk of prejudice is significant. However, Mr. Robinson's, let me see here. As previously stated, Mr. Robinson sits before this court presumed innocent, and that presumption remains unless and until each element of every offense charged against him is proved beyond a reasonable doubt. To date, this has not occurred, and the presumption of innocence remains. Balancing these factors, the court finds that Mr. Robinson's right to the presumption of innocence outweighs the minimal inconvenience of permitting civilian attire, and Mr. Robinson shall be dressed as one who is presumed innocent. Accordingly, the defendant's request to appear in civilian clothing for all pretrial proceedings is granted. Defense counsel is directed to coordinate with the jail to ensure that this order is implemented, and the court further orders that if the clothing be provided 72 hours prior to any hearing. To the second request to appear without physical restraints, Mr. Robinson also requests to appear unrestrained during pretrial proceedings. He argues that visible restraints would prejudice potential jurors, undermine his dignity, and interfere with his ability to communicate with counsel. Rule 3-14 sub 9C of the Utah Rules of Judicial Administration requires that all in custody defendants be restrained unless otherwise ordered by the court. The court recognizes that Mr. Robinson has no criminal history and no record of misconduct while in custody. However, the charges he faces are extraordinarily serious, carrying potential penalties of life imprisonment or death. The safety of Mr. Robinson, the attorneys, court staff, and the public must remain the court's highest priority. The emotional nature of these proceedings also raise the risk of disruption. Given these factors, the defendant's request to appear without restraint is denied. The court directs the sheriff's department to conduct an individualized assessment and use the least restrictive restraints necessary to maintain safety. If those restraints impede the defendant's ability to communicate with counsel or take notes, counsel may renew the motion. I wish now to also address the decorum and media restrictions. To mitigate any potential prejudice, the court will amend its standing decorum order. The media will be prohibited from photographing or visually recording Mr. Robinson's restraints and from photographing or recording him while entering, exiting, or standing in the courtroom. In making this amendment, the court has considered the factors in Rule 4-401.01 sub 2. This is a high-profile case with strong public interest. Restricting the recording of restraints strikes the proper balance between Mr. Robinson's right to a fair proceeding and the public's right to access and transparency. In conclusion, the court orders as follows. Defendant's motion to strike the sheriff's response is granted. Defendant's motion to appear in civilian clothing is granted. Defendant's motion to appear without restraints is denied. The standing decorum order will be amended to prohibit any visual recording or photography of the defendant's restraints or of the defendant entering or exiting the courtroom. This constitutes the order of the court, and a written order and ruling will be published shortly. Both defense and prosecution have stipulated to vacate the October 30th hearing. Additional time is needed to complete discovery and to file motions addressing whether non-evidentiary hearings should be conducted virtually, whether to impose any blanket restrictions on cameras in the courtroom, and any other motions that may arise. This matter is set to return before the court on January 16th, 2026 at 1 p.m. and again on January 30th, 2026 at 1 p.m. Both hearings will be heard and held in person with Mr. Robinson present to address these issues. And that concludes the order of this court. Counsel, thank you for being here. Mr. Robinson, we'll see you on January 16th and January 30th at 1 p.m. Court is now in recess.
Wow, everybody, there we are. That's horrible. Isn't it horrible? I mean, my goodness. Whew, where do we begin? I'm going to look on Twitter because I want to see if we've got any photos going on. KUTV was the pool. KUTV was pool in this particular Robinson hearing. So I want to check Utah courts. Let's see. Yep, today's hearing was held 1 p.m. local time. I have a problem when they say Tyler Robinson will appear virtually from jail, but his camera will be turned off. And we heard that his next hearings are indeed January 16th and January 30th of next year. We won't see the October 30th hearing. I don't see any photos coming through yet. It's just, I don't like it. At least he lost one motion, right? He will still have to wear restraints. But he won pretty much everything else. I agree, the sheriff is not a party to that case. The judge still needs to decide if they will allow other media, expanded media coverage. Can we record? No wonder he wasn't on screen today. The judge is saying the media can't record Charlie Kirk's alleged gunman in restraints entering or exiting the courtroom. So Tyler gets to wear civilian clothes, but he can't go without restraints. That makes sense to me in terms of, I guess, both. I've seen plenty of judges rule where the defendant gets the opportunity to wear civilian clothes. But all this business about him not appearing on screen, I guess, of course you're innocent until proven guilty. They don't want him to show up as if he's guilty, looking like an inmate. I know they don't want that image associated since it's gotten so much media coverage. Okay. But we want to see what he looks like, and that's probably what they're avoiding. We don't know what Tyler Robinson looks like now. It's just annoying. So I'm not breaking any rules. We are allowed to record today's WebEx. Will they continue with WebExes? We don't know. He still will decide certain things, but the January hearings will be in person. Tyler Robinson should be present, but he'll be in constraints, so the media can't record him in constraints unless they take the constraints off. I've seen them do that. Depends on if they'll have, his ankles shackled and his wrists. Okay. Basically, it's like no recording of Tyler entering, exiting the courtroom, or when he's in constraints, no photos, no videos. So if they bring him in, media can't record him. He's sitting there. Okay, the media can record everyone else. Of course not, usually not. Sometimes the gallery or when the jury's there, if it gets to that point. I mean, this man hasn't even entered a plea yet. Not to my knowledge. I've got to check the Utah court systems. Perhaps I should do that now. It's been a while. But I don't believe he's even entered a plea. So, I don't know. There's a lot of restrictions on this case. I know they're trying to keep everyone safe. I know it's a ton of emotion, a ton of attention. But it's annoying. Let's see what we can find. They make you pay. Pay. Tyler Robinson, I'm looking for his specific case. That would be this one. And see the latest documents, because I don't remember this one. Let's go to the correct one. I thought that's what I clicked. Ugh. You see why you hate. You hate the stupid. Now, if I do this, it'll make me pay again, of course. Pay. But I don't know, it's frustrating. Here we go. Let's look at the latest documents. I don't believe he's even entered a plea. Why does it keep showing me this tax lien? This is not what. Anyway, this is how you go through so much money. Okay. Yes, this one. I don't know what I was clicking, but I wanted to see the latest documents. Here's his felony. There we go. Any I've missed, because I keep purchasing a couple. Okay, this is what the judge was talking about, the updated request for electronic media coverage. He won this. He can appear in proceedings in civilian clothing, but he still has to wear restraints. WebEx ruling hearing, order granted permission to file overlength reply. And they have something about the state's notice of open file policy and invitation to inspect physical evidence. Let's see, I might get at least one of these. I have to remember the last documents I purchased. Order to transport, those are old. He talked about this closed, sealed hearing. So that happened, what, Friday? I don't think we knew about that. It's just, I don't like the fact that I like that he'll be in restraints. Believe me, I understand safety of the courtroom, but I don't like this media being barred from filming Tyler Robinson while he's in restraints. He walks into the courtroom, he walks out, they can't film. He's in constraints, so if he's sitting in the courtroom and he's still in those constraints, the media can't pan over and film him. Sometimes they take the handcuffs off, especially in these really long hearings, but if he's still constrained at his ankles or what have you, it's frustrating. Okay, I guess I'll just end it here, and if I find any photos, I'll put them up, I'll link to them or whatever below. Let me find a great scripture to close us out on, something hopefully with hope, because my goodness, I don't know, I don't like when media's limited, when cases are just so controlled and behind the scenes. Nehemiah 13:14. Remember me for this, my God, and do not blot out what I have so faithfully done for the house of my God and its services. All right, stay tuned. Of course, as always, we will keep track of Tyler James Robinson's case. I want to know what this is. We just know what this updated order is. Phooey. So the state's open file policy. I gotta purchase it. I might purchase several of these documents. Gotta download over here. It's such a weird system. Download there. So it's the state inviting Tyler's lawyers to review the prosecution's case file with the exception of work product. No big whoop. But let's look at this updated. See how you have to purchase every single time. Request granted. This should be KUTV, and it is. That's the person who requested the media coverage. But I wanted to see the judges. I don't know what they updated their request. Order granting. So we won't see, I guess, the rest of what the judge talked about until more documents are filed. All right, I better end this here, but I don't know, it makes me angry that we won't get to see Tyler Robinson. Basically, you can't film him or photograph him in court ever if he's wearing constraints, which he should most likely always be wearing. There you go. Thanks for watching.